As we get ready to say goodbye to 2025 and look ahead to the new year, it's important for Alberta businesses to understand the key employment and labor law developments that could affect how they manage different aspects of employee relationships. To help break down the major lessons from this year's disputes and highlight what organizations should be aware of, we're joined today by Alex Norris and Stephen Torsher, chairs of the employment group at Carbert Waite LLP. Good morning, you two. Great to have you in studio.
Good morning.
Let's start off by talking about the key developments in employment law in 2025.
Yeah, well, we saw a number of interesting decisions come out of the courts, both in Canada and also here in Alberta. One decision that was particularly interesting to us involved a severance award package that totaled 26 months. Now, previously in Alberta, there was essentially a cap of 24 months on severance. So this really raises that cap. That was something that was unexpected and something we'll be watching for moving forward.
Yeah, another thing we saw a lot of is disputes over commissions and similar kinds of compensation schemes. Really, the issue is what is an employee entitled to at the time of termination. If a commission plan or an employment contract isn't particularly clear or it's silent on the issue, then it can create some problems that could lead to disputes and potentially litigation as well.
And another case that was noteworthy involved a return to work mandate. This is something else we saw a lot of over the past year. We're also seeing it with the federal government, where employees are being ordered to return to work in office. Now, the circumstances of this case are pretty unique, but ultimately what happened is the court found that ordering this employee to return to work did amount to a constructive dismissal, and the employer was obligated to pay severance. So the takeaway for employers is be cautious before you're implementing any major changes, as that could have unintended consequences like a constructive dismissal and having to pay severance.
Yeah, for sure. What we also saw a lot of this year was strikes at both the federal and provincial level. Stephen, what are the main takeaways from labor law?
Well, like you said, we saw strikes with Air Canada flight attendants, Canada Post workers, and then here in Alberta with the teachers. One of the trends that we're really seeing a lot more of now is the willingness of the government to intervene in these disputes. The federal government used its powers under the Canada Labour Code to order an end to the strikes for those federal workers and impose arbitration. And then, of course, recently we saw with the UCP government the use of the notwithstanding clause to impose a new contract on the teachers and to prevent the courts from intervening in that decision. There's been a lot of litigation started across the country involving the notwithstanding clause in the Canada Labour Code, so that's something that we'll be watching for to see how it develops over the next year or so.
Looking ahead to the new year, how can businesses effectively prepare for 2026?
Well, what we saw throughout 2025 are examples of employers facing unexpected or large severance payouts. And so really the best way to avoid that or prepare for that is to manage your severance liability by having a clear employment contract with a well-drafted termination clause. And so we really recommend that companies consult with a lawyer. It's important for a termination clause to be well-drafted. Courts are really particular about what sort of language they will accept or not accept in a termination clause. But ultimately, if you can have that certainty set in place with a contract, that can help minimize severance liability for employers moving forward.
Yeah, and along with reviewing your employment contracts, I think it's important to take a look at the employment policies as well. The law is always changing, and it's really key to stay on top of the latest changes and trends. One of those trends that we're seeing a lot of now is the use of artificial intelligence in the workplace. It's important for employers to set rules for how and when AI should be used by the employees. There's all sorts of different concerns that can come from that. Obviously, privacy concerns depending on what the employees are inputting into the system. AI often gets answers wrong, so it's important to make sure that the work is being checked before it goes out. So now more than ever, we see that it's important to make sure that there's proper policies in place dealing with artificial intelligence.
And really just looking towards 2026, it's a good time to take a step back, look at your policies, look at your employment contracts. If you're going to implement new language or new policies, it's a good time of year to tie it to a pay increase or a bonus payment, and really just get yourself set up for success in 2026.
Thanks both of you for coming in today. Lots of great information here.
Thanks for having us.
Thank you.
And if you want more details, you can visit carbertwaite.com.